Page 73. Thereafter 73 and 74. 73 is the owner of that clinic, and 74 is the one who makes the liaison between the owner and the doctors, and also responsible for the printing materials and the advertisements of the clinic. Flag, Mullah.
Yes.
Just below the flag, you also will find one black color CPU. But this has to be gone into. No, this has to be gone into. And Malad, a prayer is pending, Malad, for search and seizure, Malad, in the clinic. But these two are very vital. Your lordship will kindly allow us to do this part and come back to your lordship, Malad, with a report. But this part is extremely important. This is with regard to the facts. Thereafter, what I want to address, Malad, your lordship, Malad, with regard to the query which fell from your lordship, Malad, that's a separate aspect altogether.
No, till date, there is no documentary evidence. I'm asking a specific question to show that any prescription, any letterhead of the accused where he expresses that he is MS ENT.
Malad, the accused was not using a letterhead like we generally see, Malad, with regard to the doctors in his own letterhead. That is the first issue. If he is not using that letterhead, Malad, that is beyond our control. Your lordship will have to see what he was using. That is at page 80. Kindly see page 80. Malad is at page 80, Malad. So he is using, Malad, the prescription of the clinic. This clinic is describing him in a particular way, which according to one of them is after information to him. And this is not a one-time event. He is sitting there for the last few months. Clinic is closed, but he was sitting there at least for 1.5 years.
More than that, 3 years, 70.
3 years.
If you say page 80.
Therefore, Malad, it is not something that has escaped his eyes. It is not something that he is not aware of. It is something that he has allowed the clinic to do, allowed the clinic to run for a very long period of time. And once he is using that prescription, he is giving the clinic.
Then one thing, sir, where from have you obtained this particular document?
3 and 5 and 7.
5 and 7.
But this is how they are advertising it. This is how the clinic is being, the people are being approached with regard to the clinic.
From where have you obtained this?
But this is from the complainant.
Huh?
This is from the complainant, Malad, but it is of this Shobik Beda, who is the employee of that clinic.
That is why I am saying it. The complainant is a resident.
But this is all over social media. This is everywhere.
You have obtained from social media.
The complainant has obtained it from the social media and given it to us. The further examination of it is required to be done. And this is the same person, Malad, that is the statement has been recorded, who says that it is after his permission, he has described himself so and so.
All right. Complainant includes this along with the complaint.
No, it is separately. No, separately. Subsequently supplied.
When was this obtained actually?
At page 3, second paragraph. Page 3, second paragraph. The clinic is not allowed. We believe some material will be available. This part with regard to the CPU and the part with regard to the clinic, that may kindly be allowed by your lordship, Malad. Otherwise, Malad, that will be throttling the investigation too early, Malad. Well, search has been, in fact, been allowed, but we have not carried out the search in the clinic. because the matter was pending before your lordship. But even if your lordship allows tomorrow or day after, my lord, we can. But that search and seizure is extremely important in the clinic.
Is the initiation of a proceeding like this permitted under the law?
The my lord,
Pick up a complaint and start research work.
my lord, I'll tell you, lordship, my lord, apropos to what fell from your lordship, my lord. My lord, your lordship has seen the complaint, my lord, and the FIR, my lord. All three are cognizable offences. Now, my lord, preliminary inquiry itself, my lord, will not vitiate my investigation. My lord, the law with regard to that is quite well settled. My lord, if I may assist your lordship, my lord, on that. If your lordship kindly take 2019 SCC 87. 2019 87. 19, volume 19.
2019 is
Page 87. Now kindly take from 27.
Page?
What?
Paragraph or page?
Page, paragraph 27. Since I was telling the page to my learned senior, so
Yes.
my lord, I have not brought Lalita Kumari separately, my lord. It is extensively quoted in both the judgments which I have placed. Kindly take, my lord, 27. Coming, sorry, my lord, paragraph 27. I'm sorry. May I place it, my lord? Coming to the appeal filed by the accused officer, Mr. So-and-so learned senior counsel vehemently argued that a preliminary inquiry before the registration of a crime was mandatory. Reference was made to a judgment in Lalita Kumari as well as judgment in State versus Hiramat.
No, I am not on Lalita Kumari, sir. The thing, this Lalita Kumari was. See, I don't know the exact. I can't. Maybe near about out 173 whole 175 174 of BNSS, but 157 of the earlier CRPC vested the power with the police authorities to have their subjective satisfaction for registration of the FIR. Now, even if Lalita Kumari is not, Lalita Kumari has spelled out in respect of medical negligence cases.
No.
This is not a case of medical negligence.
So it discloses a cognizable offense. It discloses the cognizable offense with regard to breach of trust, with regard to cheating as well as impersonation.
So that is what I am saying. Discloses means discloses in what form?
But discloses in the complaint itself. Today we are between
Sir,
the complaint and the FIR.
Complaint was on a single sheet of paper without any documentation. That is what.
It is on that same day. That is why I refer to this.
That is why I am also all 155. You record the FIR. Subsequent collection of documents are after that. So, had it been a day later after taking into account all the documents, what would have spoiled the system, sir?
But it would not
This
have.
is a case
But
of
it is not mandatory. That is what I'm trying to say.
No, one thing is mandatory. You must understand you are a state, you are guardian of the citizens of this country. If you start unleashing your power, people will become helpless.
But there is no
basically.
question of unleashing the power or the might of the state in this case. We are on the point that the complaint was disclosing a cognizable offense.
Complaint was not disclosing a cognizable offense without a supporting document.
But kindly take serial number 1 of that complaint. Serial number 1 of the other parts we do not. A layman, he may not know that police is no one to cancel the license. That's a different thing, or the registration. He has made those prayers. Let us not go into that. But kindly take serial number 1. Serial number 1 is impersonation.
He presented himself as MSENT. That's a case of impersonations. That is what you want to say, sir?
Yes.
Then at that time.
And that case has been made out, Mullah.
That case has been subsequently made out. At that time, at 155 hours, what was there before the police officer concerned?
Well, kindly, Mullah, that is not the time for collection of evidence. Mullah, the collection of evidence is at time of investigation. No, but kindly takes the complaint once, either from the CD or the writ petition. Yes. In second page of the CD is also there, Mullah.
Second page of the CD I am seeing.
Yes. Third line I am reading. Third line. তিনি একটি এমবিবিএস গ্র্যাজুয়েট এবং বর্তমানে এমএস ইএনটি প্রশিক্ষণ রয়েছেন তা সত্ত্বেও তিনি নিজেকে এমএসইএনটি বলে মিথ্যা উপস্থাপন করেছেন এবং গত কয়েক বছর ধরে বেআইনিভাবে বেসরকারি চিকিৎসা চালাচ্ছেন। দেন নাম্বার 1, ডক্টর নাইয়া তার এমএসইএনটি ডিগ্রি সম্পূর্ণ হয়েছে বলে দাবি করেছেন, যা সম্পূর্ণ মিথ্যে। তিনি এখনো একজন প্রশিক্ষণরত পিজিটি।
This is impersonation, case of impersonation, nothing more than that.
That automatically, my lord, entails that the cheating, and also, my lord, entails the criminal breach of trust, where he is projecting to the patients to be someone that he is not, of having the higher degree that he is not having, or where he is practicing, etc. My lord, it matters there. It might matter there, and it is happening in front of his eyes for 1.5 years. He is not saying that remove the advertisements, etc.
Criminal breach of trust. Let me see the definition. If the definition has not changed, I believe.
316 subsection 1.
Yes.
Whoever being in any manner entrusted with property or with any dominion over property dishonestly misappropriates or converts to his own use that property or dishonestly uses or disposes of that property in violation of any direction of law prescribing the mode in which the trust is to be discharged or of any legal contract express or implied which he may made touching or discharge of such trust or willfully suffers any other person to do so commits criminal breach of trust.
Where from it is coming? Which part, sir, is trust?
Lord, he
Is it, sir, you are a lawyer. You are substantiating the 419 I'm accepting.
Yes.
They may be, but
is 318 one.
316 is coming.
But that has to be investigated. If not,
no, which job? Sir, the property aspect is not coming over here.
But kindly take 318, kindly take 319.
316 is coming.
Subject matter of investigation, Malad, throttling it at the beginning, Malad, will not.
I'm not. Why are you presuming that I'm throttling?
No, Malad, I'm arguing not to throttle. Malad, my argument is.
I'm asking you questions as a judge. I'm entitled to do that, sir. I'm asking you where 316 is being applied in what manner, sir? Repose trust and faith as used in English language is different from criminal breach of trust as defined under the BNS or the Indian Penal Code.
Malad, 318, 319 is at least clearly made out here. No? Clearly made out. No.
That will come to that, sir. I'm not saying made out or not made out. That's a 316 is not made out palpably on the face of it. This much I can say.
আমি যাকে ইম্পারসন করলাম সেই কমপ্লেন করছে না, আমি এসে কমপ্লেন করবো।
And your lordship will kindly take it with the illustration A.
Of 318?
318.
Subject matter goods are there, sir.
So 318, by deceiving any person fraudulently or dishonestly, induces the person so deceived to deliver any property to any person or to consent that any person shall retain
What
any
are
property.
you reading? Which part?
318, Malad.
18?
Subsection 1.
Subsection 1, illustration A. Which part you are saying?
A.
Illustration A.
Illustration A.
That is civil services, it is there.
It's by way of illustration, pretending to be someone else. Pretending to be someone else. So what has been given in the FIR is 318.4. We are reading 318.1 for the understanding.
I say impersonation, there is an accusation. I am not saying
Yes.
For impersonation, I am saying that even if it is a case, that's a different argument. I'm not saying that, sir. So far as impersonation, উপস্থাপনা করছে, that makes out a case of impersonation.
Yes.
Now, for that impersonation,
Yes.
at the relevant point of time, the person who was registering the case He had no document in his hand at that point of time.
My lord, the document comes at the investigation stage. This is where we are at. My lord, what your lordships is, my lord, the query which is falling from your lordships is again going back to that question of preliminary inquiry, that why no preliminary inquiry was conducted, and some documents, some material should have been taken by the person registering the FIR to be subjectively satisfied that a case is made out. But that whatever is prior to that, my lord, will again entail to that preliminary inquiry. There, my argument is that non-happening of that preliminary inquiry does not, my lord, vitiate the FIR. That is the dictum of the Supreme Court, my lord. If your lordship again, my lord, takes that judgment at paragraph 30, which I was trying to place, my lord.
Yes, please.
I was only at 27, my lord. Kindly takes 30 of that. January, by a notice of 17th of January, he said that I will not come on 20th. So he could have come and given us the assistance that we required in course of our investigation. So had it been so that he helped us, my lord, this part would have applied for them, I would agree. But my lord, since they are also trying to evade our notices, my lord, this part may not apply to them. The second part, where the powers of under 226 has been discussed. So, my lord, either way, your lordship will kindly allow us for this search, my lord, which is outstanding, my lord, and allow us to come back with the report on the materials that we may gather therefrom. And that CPU has to be sent, my lord, for examination.
Yes. So,
The fundamental question which you have raised has not been answered. The FIR as it is does not disclose any cognizable offense. But the gentleman is so much aware of that, what I am doing, I am a PGT student, I am doing this and that. He does not ever mention that he comes to know that Mr. X was treated claiming himself to be a ENT, I mean the MSENT. Not a single thing. Kindly read whatever read it, Lord, I would again say if this Lord empowers a police to go on roving investigation, and they were making the people to make a statement in support of their case. অভিযোগের মূল বিষয়বস্তু মিথ্যা পরিচয় ডক্টর নাইয়া তার MSNT ডিগ্রি সম্পূর্ণ হয়েছে বলে দাবি করেছেন, যা সম্পূর্ণ মিথ্যা। Why did I claim that I am MSNT? তিনি একজন প্রশিক্ষণরত PGT. Well, he comes to know because I'm involved in the doctors movement. PGT students are there. Therefore, this has come to his knowledge by this process. বেআইনি চিকিৎসা প্র্যাকটিস, ডাক্তার নাইয়া কোনো অনুমতি ছাড়া যোগ্যতা ছাড়াই বেসরকারি চিকিৎসা চালিয়ে যাচ্ছেন। But how could a man on the street would know that somebody is carrying on practice in private arena? এটা রোগীদের জীবন ও স্বাস্থ্যকে ঝুঁকিতে ফেলেছে। কোন রোগী, কে একজন ঝুঁকিতে পড়েছেন? প্রমাণাদি নথি প্রমাণ করে যে হোয়াট আর দ্য নোটিস। একজন চিকিৎসা করে যাচ্ছেন এবং মিডিয়াকে এটি রোগীদের জীবন স্বাস্থ্যকে ঝুঁকিতে প্রমাণাদি নথি প্রমাণ করে যে তিনি একাধিক স্থানে চিকিৎসা করে যাচ্ছেন এবং সোশ্যাল মিডিয়ায় নিজেকে প্রমোট করেছেন। Where is that document that I have promoted myself in the social media? Because they have procured one advertisement by a organization who had organized a free camp, and I was invited to give the free service. That is also in the social media. Do not take this care. And now get a statement from a person that yes, I have asked him to advertise this. But if the police goes and say, make a statement like this, would anyone have courage in this state at this time to say, no, I will not make any statement to your desire? Now, the pertinent question which has been asked by your lordship, what is the authority of the police to start investigation on this complaint? An iota of example, had it been there, that which he knows his friend, he knows his relative who has suffered because of this. Now, after getting this, that I say, Lord, it's deliberately it was done only to see that he does not remain a part of the doctors' movement. How this gentleman Raju Bokshi, he stays in Shukanto Nagar, knows everything about me and my family and goes sends police to the Canning, where from I hail.
In criminal jurisprudence, locus cannot be an issue to be discussed, my lord. There's no question of locus in criminal jurisprudence.
Lord, I again will reiterate that question is probity. Someone is making complaint without being affected by any way, just to get one person harassed by the police because police is my control. And that's the way it is done. My lord would be kind enough not to permit them to carry on an investigation. If anyone is really affected, my lord, they have every right to come, they file an FIR. If somebody comes and say that I have suffered because of his treatment and he claimed that he is MACNT, as of now, they could not find out one individual who has allegedly suffered because of my treatment. And their grievance is why I am taking private practice. And these FIR relates to the statements made by the political leaders that doctors are making private practice and they are not giving their attention to the official duties. This is the reflection of that. This is the creation of this. And none of this section, people also kindly permits me to place the relevant section. None of these sections are invited in this case. Apart from the question that Supreme Court judgments have nothing to do with these matters, but still, kindly come to Lordship has read it. Section 316. And I am told, my lord, anyway, I don't want to prejudice the court.
No, I have annexed order.
The same IO is involved with the case of Kalotan Dashgupta. The same IO.
I have annexed that order.
The same.
Now, my lord, yes. 316, my lord, Lordship has read it. I don't want to waste time. There is no question, nothing relates to criminal breach of trust. Then kindly come to my lord 318, cheating. Whoever by deceiving any person who has been deceived, has somebody discomfort, for purpose fraudulently dishonestly induces the person so deceived to deliver any property to any person or to consent that any person shall retain any property. But why is the question of any property? Where somebody comes to me for legal advice, he feels that my advice was wrong, but he can also go and complain. But Z will come and say, no, I know, he and so, being a senior, claiming to be a senior advocate and advised me, that was criminal offense. And police will go, raid my house. And then again, boldly says, kindly give us time, we shall go, search, we shall create evidence.
Anyway, that's a final argument case applicable.
No, never at this stage, the preliminary stage, Joshua would be kind enough to stay the entire proceedings. The FIR would not be able to stand the scrutiny of the court, it has to be quashed. None of these offenses which is made in the FIR has been made out by this complaint. And these judgments which are cited with deepest of respect to understand, in those cases the court records a credible FIR has been lodged. Therefore, being a credible FIR of corruption, the department comes forward to file an FIR, that does not vitiate because of not having preliminary inquiry. All three judgments based on that. But here, my case, the FIR, alleged FIR does not disclose any offense. And on the basis of this, the harassment is going on. We'll kindly consider this aspect.
Lord,
Suddenly raises and seizes entire thing from my native place where I stay. What has been seized? Kindly see, Lordship was asking this question, page 89. What have they seized from my house? What prompted them to send such a big police force to the Canning from Kolkata? It reflects the malafide intention. Kindly turn to page 89. This is the seizure that they have made.
89 of your
of the petition behind my back. And where? Date and time of seizure on 16th of January. And the so-called complaint is made on 9th of January. Place of seizure, house of Dr. Asfakulda Nair, so-and-so, PS, Harut Point, Coastal District, Parganas.
Even prior to serving notice on me.
From whom seized as produced by Ovaila Nair, so-and-so, 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 the brother of the petitioner.
Illiterate family members.
What are the seized? One photocopy attempt certificate in the name of Dr. Asfakul Nair, issued by Calcutta National Medical College. Therefore, this is a document issued by the government itself. One photocopy of order in the name of medical graduate Dr. Asfakul Nair, having memo number such as issued by the medical superintendent cum principal Calcutta National Medical College. one photocopy of order in the name of medical graduate so and so issued by the medical superintendent. These are all official documents issued by the authorities.
The list was not handed over to us.
No. This was seized. And then next page, one photocopy of annexure A memo to such and such, data substance having page number 87. One original income cum residential certificate.
Services as a medical practitioner. The second part of the complaint relate to 4 separate serial numbers with subheadings. The first being led the protest in respect of Arjikar hospital movement for improving medical facilities, addressing grievances of healthcare professionals, and raising public awareness about issues in the healthcare sector, which gained momentum after the incident of ghastly rape and murder of a junior doctor at the hospital was a cause for the state to initiate such proceedings.
Mine is shortly.
I will also take a leave after this.
But I'll come back because I have 30.